but you're just the dude. You weren't hurt at all. I know that makes practically no sense, but legally it makes sense. And again, this is why everyone hates lawyers. We are the Armed Attorneys. Today we're talking about a case out of the state of Wyoming that is trying to legalize machine guns for all of us. We're going to talk through who brought the suit, what's happening to it, where we go from here, and why some judges are just so stupid. But before we get started, show your support for the Second Amendment by hitting the like button. And today's episode is brought to you by our friends over at Aura.
But to start things off and give us a little bit of background, the case that we're talking about was out of the United States District Court for the state of Wyoming. We're going to go into all those case details, but we have to know a little bit about our general prohibition on basically new machine guns.
Right.
But we go back to May 19th, 1986 with the Firearm Owners Protection Act. We all know that because, hey, it protects firearm owners. Don't we all want that? Except that, so it gave us some good things with the safe passage provisions of that law, but at the same time, it criminalized generally the possession of machine guns that weren't in circulation, registered under the National Firearms Act. This is 18 U.S.C. 922-0. And so we have that general prohibition. We have a counterpart over in the Code of Federal Regulation, but that's exactly what that law states. Generally illegal, unless existing and a tax paid and registered prior to that date. So what does that do? Well, that drives up the supply of machine guns. So
Drives up the cost.
Yeah, it drives up the cost. And it also interferes with, when folks want a new machine gun, well, that goes out the window, right? We've nearly 40 years now where we don't have new machine guns out for civilian use.
No.
What?
40 years.
Close.
That reminds me that that's my birth year.
Uh-oh. All right. Well, so we have that, but that enters Mr. Jake DeWild, and we have to talk about his case, what's going on here, why it's a little bit different, and what this means for possibly legal machine guns in the future.
Yeah, well, I would say first, kudos, Mr. DeWild. It is not easy to represent yourself, particularly in federal court. And I mean, for a pro se plaintiff, he has done an admirable job here, but he is in fact pro se. And so he has filed suit and essentially alleged that I submitted a form to the ATF. I wanted to manufacture a machine gun.
Yeah, Form 1.
And I was denied, right? Which, of course, they're going to say, no, you cannot manufacture a new machine gun, Mr. DeWild. And that provides me a wrong that I need redressed by the courts. That provides me standing, and it violates my Second Amendment rights. Let's giddy up, right?
Yeah. Representing yourself pro se can save you a lot of money. Lawyers ain't cheap, but you know what else isn't cheap? Identity theft. In 2022, the U.S. Federal Trade Commission reported that Americans lost $8.8 billion to identity theft and fraud, a 49% increase over the previous year. But you can protect yourself now at a fraction of the cost. That's why I'm excited to tell you about today's sponsor, Aura. You've heard me tell this story before about my sister. She's a former felony prosecutor. I Googled her number one time and her home address came up, which is horrifying because under state law, her information is supposed to be hidden.
That's where Aura comes in. Aura has almost every internet safety tool you'll ever need all inside one app. The app features a VPN, password manager, real-time credit and identity theft monitoring, internet parental controls, and protects your devices from malware. And on top of data breach notifications, Aura proactively identifies data brokers exposing your information on the web and automatically submits opt-out requests on your behalf. They'll even opt you out of junk mail and telemarketing lists.
Let Aura do the hard work of keeping you safe online. If you sign up right now, Aura will give you a 2-week free trial with our link. Go to aura.com/armedattorneys to start your free trial, also linked in the description below. All right, so for those who are following along at home, if you want to check this case out, this is in the United States District Court for the District of Wyoming. This case number is 23 CV03. We have a fundamental challenge to 18 U.S.C. 922-0. We have that Form 1 denied, and the court does two things, looking at standing and a Second Amendment violation. Let's go through standing first, and I think there's some issues here.
Yes. So, I mean, essentially, the court throws him out in the first opportunity they can throw him out, which is called a 12b6 motion in federal court. And they say, first of all, you don't have standing. And this is one of the things that does make it really, really hard to try to represent yourself, is that essentially he as his trust and as trustee, wanted to make said machine gun. When he brings suit, he doesn't bring suit as the trust, right? The trust isn't a named plaintiff. Himself as trustee is not a named plaintiff. It's just him as a dude. And you would say to yourself, why does that matter? And practically speaking, I'm with you. However, for standing purposes, it does matter. The wrong plaintiff brought suit. And so, just on a pure look, you're just a guy. You weren't personally denied the right to make a firearm. The trust was, and perhaps you as trustee, but you're just the dude. You weren't hurt at all. I know that makes practically no sense, but legally it makes sense. And again, this is why everyone hates lawyers. So
yeah, and the other thing that jumped out to me in the court addressing the standing, saying he doesn't have standing, they talk about, as part of getting standing, you have to have harm, not hypothetical harm, has to be real harm. And part of this is we in the gun community, we all fill in the gaps. We all know exactly what's going on here. We know exactly how he's harmed, but he doesn't get that stuff really out on the record. And so you have to, this is just good law practice when you're filing a complaint or whenever you're preparing a lawsuit. No assumptions.
Yep.
Everything is spelled out in black and white of this is why this applies to me. This is how I was harmed. Here's all the reasons I was harmed. And so here he just says, my Form 1 was denied. I wanted a machine gun. There's not a whole lot of articulation of the actual harm. And I think that's just, that's good law practice.
Right. And again, it's just tough. It's tough to be pro se.
Yeah.
So we've got that. And the court actually could have just stopped there and said no standing. But then they also just smacked down his Second Amendment arguments, I think because they didn't want him just to refile as the trust and as trustee and then have to go through the Second Amendment analysis. So for some reason, they decided to go ahead and say no standing, but also we don't care about your machine guns. And this is where, and Lord, I am, going on the record and saying this, and I have no idea what sort of hell I'll unleash on myself if I ever decide to go practice law in Wyoming. But this judge does not do this judge makes a fundamental error in Second Amendment analysis that I find very, very obnoxious. So essentially, like the main conclusion, right, is you do not have a Second Amendment right to machine guns.
Yeah.
They're unusual. They're not in common use. They are,
not covered
dangerous.
by the Second Amendment.
You don't have a Second Amendment right to a machine
The
gun.
reasoning of how they get there is crazy.
It is crazy. So you want to start with the Heller reasoning and then we'll move forward?
Yeah. And I think the reason that the court goes and it does this Second Amendment analysis, because I think the appeals court is going to be very forgiving on the standing issue. And so, that's probably why we get into this as well. But the court goes, hey, we have all this long history of case law saying that machine guns are dangerous and unusual, and that New York State Rifle and Pistol Association does not have a practical effect on that analysis.
Right. And so this is...
read the quote.
It's
crazy.
Find it. I've got to find it. Okay, so we have this judge going through federal case, Supreme Court, circuits, case by case by case by case. And it's like, 6, 7, 8 cases that basically say no Second Amendment right to machine guns. Nope, nope, nope. Interesting. All of these cases, you start looking at the dates. They're from years such as 2012, 2006, 2009. And you might say to yourself, in 2024, what has rocked the gun world in recent times?
Yeah, New York State Rifle and Pistol Association v. Bruin.
Nothing before 2022 even matters. If it happened before 2022, is it even really Second Amendment precedent?
Yeah, well,
not if it rules against the Second Amendment.
Well, and what the court does, and they say it doesn't change their analysis.
Oh, this is. Yeah,
here, the
we
quote?
read this sitting in the office before we started filming, and I said, this is the single stupidest line I have ever seen in a judge's opinion, and I stand by it. So we go through all of these cases, and the conclusion being, machine guns, you don't have a right to machine guns under the Second Amendment, and then has the audacity to write, circumstances have not meaningfully changed since these pre-2022 decisions.
That is absolutely wild.
That is
no pun intended.
Is absolutely wild. That is that is the stupidest line I have ever read in any decision.
Yeah, and I think, in the I think the court also does a really bad job in relying on Supreme Court dicta.
Mm-hmm.
And so when you have a court case, what is binding law is what's called the reasoning. That's the decision, and that's when they're
In the
addressing,
holding.
yeah, in the
Mm-hmm.
holding, and they're addressing they're addressing the issue before the court. And when they talk about things that are not before the court, we call that stuff dicta. It's extra language. It's instructive. It might be
It's
helpful.
instructive, might be helpful.
It might show the justice's hands on how they will rule in the future, but it is not binding precedent.
Mm-mm. Nope. And so what we have is we have a judge who cites dicta out of Heller as something that even matters. That even matters.
Yeah.
It doesn't. For a myriad of reasons, it doesn't matter.
All right. So what's next, and why is this case important? The first things first. Why this case I think is really, really important, and I like it personally, is because we're attacking, and this is the way we need to knock down Second Amendment infringements. As frustrating as it is, we're not going to get these. The world flips on its axis overnight. We're going to get these kind of pinpoint issues. This is a pinpoint issue. Machine
Yes.
guns, pinpoint. We're not dragging in all this other stuff. And normally, when we see challenges to machine guns, because I'm watching these cases, it's convicted felon who's robbing bank found with machine gun. Well, guess what? The court doesn't want to mess with machine guns when we got
Right.
all this other material before us. So this is great because we got machine guns only. And so that's why this case is great. And it's just hyper focused. Now, where are we going from here?
So this was in the district court. Mr. DeWild has appealed to the 10th Circuit. Phenomenal. The 10th Circuit is middling on firearms, so it's not as good as the 5th Circuit, not as bad as the Ninth. It should be an interesting case to watch. And I think that Richard is correct in his assessment that the 10th Circuit will probably be a little bit more forgiving on the standing issue, and then hopefully a lot better on the Second Amendment reasoning, but we will wait and see.
But we're going to be following this case for you. So make sure, if you're not already, subscribe, because we'll keep you in the loop as to what's going on with this. But we hope you enjoyed the discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And please question and comment for us below. Until next time, we're the Armed Attorneys.